This lectures two distinct concepts: how the statute of frauds affects the enforceability of a contract and how the parole evidence rule excludes outside evidence offered to modify a contract. Now, a contract that is otherwise valid may be unenforceable if it is not in proper form. So certain types of contracts are required to be in writing. If a contract is required by law to be in writing and it's not, it may not be enforceable. When a contract has been put in writing and a dispute arises that ends up in court, the parties may not introduce evidence of prior written or oral negotiations or promises or contemporaneous oral agreements that contradict the contract terms. This is the parole evidence rule. For it to apply, the parties must have intended their writing to be their final agreement. Of course, as with the other concepts, there are always exceptions. Some of the things we're going to look at that are required to be in writing involve contracts involving the interest in land, contracts that cannot by their terms be performed within 1 year from the date after the contract's formation, collateral contracts such as promises to answer for the debts or duties of another, promises made in the consideration of marriage, and under the UCC, contracts for the sale of goods priced at $500 or more. Now, to be enforceable, certain contracts have to be in writing, even if both parties acknowledge there's been an oral contract. It may not be enforced, including in all states. So the primary purpose of this requirement is to provide reliable evidence of these contracts, a writing signed by the party against whom enforcement is sought. Now, state statutes vary, but a contract that is oral, when it is required to be in writing, is normally voidable by the party who does not wish to follow it. Contracts for the sale of land, including physical objects that are permanently attached to it, such as buildings and fences, trees, minerals, timber, and for the transfer of other interest in land, such as mortgages, must be in writing. A contract that cannot by its own terms be performed within 1 year from the date it was formed must be in writing to be enforceable. Now, the 1 year period begins to run the day after the contract is made. If performance is objectively impossible, which means performance must be objectively impossible within a year to require a writing. This is an example here where a contract to provide 5 crops of tomatoes to be grown on a specific farm in Illinois would be objectively impossible to provide within a year. No farmer in the state of Illinois can grow 5 crops of tomatoes in any single year. This would be required to be in writing since it's impossible to complete within a year. Now, if performance is possible, even if improbable, if performance within a year is possible, then the contract doesn't have to be in writing. So in this situation, Janice enters into a contract to create a carving of President Barack Obama on Mount Rushmore. Now, technically, it's possible for this to be done within a year, although it's unlikely. Just to give you a heads up, Mount Rushmore, it took 14 years to complete those carvings. Now, a collateral promise is a secondary promise that generally, where what happens is a contract in which a party assumes a primary obligation, and it doesn't need to be in writing to be enforceable. Now, secondary obligations, promises made by one person to pay the debts or discharges the duties of another, if the latter fails to perform, must be in writing for it to be enforceable. If the main purpose of the guarantor in accepting the second liability is to secure a benefit for himself or herself, then the contract need not be in writing to be enforceable. This is called the main purpose rule. So as you see here, Laura has just moved from Indiana to Boston, is looking for a place to live. Well, Carrie, Laura's friend, owns some property and agrees to lease 2 acres of land to Laura. Laura asks Carrie if she can build a house on the land, and Carrie readily agrees, knowing that a house will drastically increase the value of her property. So Laura goes to Fleet Bank and applies for a $1 million loan to build a house. Carrie orally promises the bank that she'll be responsible for paying back the loan if Laura doesn't. Now, in this case, even though Carrie's promise is oral, it will be enforceable because Carrie's main purpose in making the promise to the bank is her interest in seeing the house built on her land. So any kind of writing will be adequate to satisfy the statute of frauds. However, the writing must contain the essential terms of the contract, including who the contracting parties are, the subject matter of the contract, and the terms and conditions of the agreement. The writing must be signed by the parties to be charged, and if any party to the contract doesn't sign it, that party cannot be held liable under the contract. But as we see in this main purpose rule, because of the benefit that the party will receive, then it doesn't have to be in writing in order for it to be enforceable. Contracts made in consideration of marriage must be in writing. Note that this is not a contract to marry. This is a contract in consideration of marriage. So, for example, Evan orally promises to marry Zora, and Zora promises to marry Evan. Now, this is not a contract in consideration of marriage. This is just a contract to marry. Evan and Zora make an oral contract in which Evan promises to buy Zora a mansion in France if Zora marries Evan. Now, this promise is not enforceable because it violates the statute of frauds. Evan's promising the mansion in consideration of Zora marrying him. Therefore, this contract must be in writing. Now, a prenuptial agreement is an agreement entered into in contemplation of marriage, specifying the rights and ownership of the parties' property. The drafting and the signing of prenuptial agreements are really at odds with the very concept of marriage. After all, the parties purport to be in love with each other and desirous of sharing all aspects of their lives. Under these circumstances, the thought of involving lawyers in the negotiation of a prenup really seems inappropriate, but nonetheless, prenups are drafted and entered into every day. Cases occasionally come before the courts in which a party to a prenup claims that the agreement should not be enforced because one party was not advised to consult his or her own attorney before signing it. So in many jurisdictions, courts regard the advice of independent counsel as a significant factor in determining whether a party signed a prenup agreement voluntarily. So in other words, if a prospective spouse did not have the advice of her or his own attorney before signing that agreement, then that could indicate that the agreement was not signed voluntarily. In one case, a woman challenged the enforceability of a prenup on the ground that her husband's lawyer, who was hired to draft the agreement, didn't advise her to have it reviewed by her own attorney. Well, the Supreme Court of North Dakota held that the agreement could be unenforceable for that reason. In a subsequent case involving very similar facts, the Supreme Court of North Dakota reiterated that adequate legal representation will often be the best evidence that a spouse signed the agreement knowingly and voluntarily. So many courts have been suspicious of prenups involving a waiver by the future wife of all spousal support in the event of marriage or divorce. The reasoning's been that any prenup support waiver might undermine the permanency of the marital relationship, which could be really contrary to public policy. Next, we're going to talk about the contract for the sale of goods. Now, the UCC requires a writing, for it to be in writing, for a sale of goods priced at $500 or more. The writing need only state the quantity, term, and be signed by the party to be charged. The contract will not be enforceable for any quantity that is greater than that set forth in the writing. Now, there are some exceptions to this rule of having it in writing. Partial performance, admissions, and promissory estoppel, along with special exceptions. So, on a contract for a transfer of an interest in land, if the buyer has paid part of the price, taken possession, and made permanent improvements to the property, and the parties cannot be returned to their pre-contract status, then a court may grant what's called specific performance. Under the UCC, an oral contract is enforceable to the extent that a seller accepts payment or a buyer accepts delivery. Next, admissions. So in some states, if a party against whom enforcement of an oral contract is sought admits under oath that a contract for sale was in fact made, then the contract would be enforceable. Under the UCC, this will, of course, be enforceable only to the extent of the quantity admitted. Then, promissory estoppel. Some courts have used the doctrine of promissory estoppel to allow parties to recover under oral contracts that would otherwise be unenforceable under the statute of frauds. So, the person making the promise must foresee that a promisee would rely on it, and there must be no way to avoid injustice except by enforcing the promise. Oral contracts for customized goods and oral contracts between merchants that have been confirmed in writing may be enforced in certain circumstances. There was a court case where a contractor developed and created custom cabinets for a home, and the homeowners tried to get out of it. And basically the rule applied that because these items were customized specifically for their home, then they were required to pay for it even though it wasn't in writing. Now, in regards to the sufficiency of the writing, the statute of frauds does require a writing signed only by the party against whom enforcement is sought. So any confirmation, invoice, sales slip, check, or telegram, any of these memorandums can constitute a sufficient writing. The writing doesn't have to consist of a single document to constitute an enforceable contract. Under the UCC, a writing need only name the quantity. Under the statute of frauds covering transactions other than the sale of goods, the writing must name the parties, the subject matter, the consideration, and the essential terms with reasonable certainty. In some states, contracts for the sale of land must state the price and describe the property with sufficient clarity to allow them to be determined without reference to outside sources. In regards to signatures, only the party to be held liable need have signed the writing. This signature can be no more than an initial and can be anywhere in the writing. Under the definition of e-signature in the Uniform Electronic Transactions Act, a party's name typed at the end of an email note satisfies the statute of frauds signature requirement. No evidence of prior oral or written negotiations or agreements or contemporaneous oral negotiations may be used to change the terms of a written contract. Parole evidence is evidence, oral or written, outside the writing and not made a part of the contract by a reference in the writing. There are exceptions to the parole evidence rule. So parole evidence is admissible in cases involving contracts subsequently modified. So evidence of the subsequent modification, be it oral or written, of a written contract is admissible, but an oral modification may not be enforceable if it brings the contract under the statute of frauds. Voidable or void contracts, this may occur if a contract was entered into under deception or was induced in bad faith. And ambiguous terms where the contract just can't be understood because of the conflicting terms. Contracts that are incomplete would then require oral evidence. Then customary practices, which may be common among certain people. Under the UCC, evidence can be introduced to explain or to supplement a contract by showing a prior dealing, a course of performance, or usage of trade. And then orally agreed upon conditions. Proof of such a condition does not alter or modify the written terms, but affects the enforceability of a written contract. And then lastly, obvious errors. A contract with an obvious or gross clerical or typographical error must clearly not represent the agreement of the parties. Therefore, oral evidence is allowed. The key in whether a written contract is intended to a complete and final embodiment of the parties' agreement. If the contract is only partially integrated, then evidence of consistent additional terms is admissible to help supplement the written agreement. So in conclusion to this lecture, it's always best to have every contract you enter in writing, because even the writing in and of itself can be ambiguous and not in clear terms. So make sure all contracts are clearly in writing. There are times when a contract is not required to be in writing. However, there are exceptions that contracts must be in writing in order for them to be enforceable.